Coming to you from the poop deck of the NYPTI Ark, floating high above the rain-soaked Capital District. Welcome to this edition of the NYPTI Practice Tips. Today we will be discussing the evidentiary issue of opening the door. In any trial, there will be evidence that you want to introduce, but due to the existing evidentiary rules that prohibit the introduction of such evidence, such as mugshot photo identifications at the present time, or due to a preliminary determination by the court, such as in a Molyneux or Sandoval ruling, you are prohibited from doing so. During the trial, the defense may be conducted in a manner which allows for your application to the court to reconsider the admission of this evidence. We commonly refer to this as the defense opening the door. You should always be on your toes to recognize situations where the door has been opened and make a timely application to the court. The defense may open the door at just about any time during the trial, from the opening statement to the summation. In the case of People v. Brown from First Department in 2016, the defendant opened the door to the introduction of evidence that would normally not be admissible. The court wrote, by arguing in his opening statement that a police officer had rushed to judgment and arrested the defendant without conducting a proper investigation and without even hearing his side of the story, the defense counsel opened the door to otherwise inadmissible testimony regarding the defendant's post-arrest silence. When a defendant establishes his or her defense in the opening, this can open the door to the people presenting prohibited evidence on their direct case, not needing to wait for their rebuttal case. In People v. Deal, another First Department case from 2006, the appellate division found that the defense had opened the door during its opening statement to the admission of evidence to refute the agency defense to which the defense had committed itself in its opening. The court wrote, after defendant's opening statement in which he committed himself to an agency defense, the court properly granted the people's request for permission to elicit additional matter relating to defendant's history of drug trafficking. This material was limited in scope and was relevant to rebut that defense. There is no merit to the defendant's claim that he was unduly prejudiced by the timing of the people's application. In People v. Rojas, the Court of Appeals found that the defense had opened the door with a combination of its opening statement and the cross-examination of the people's first witness. The court's majority also made a clear statement that the introduction of uncharged crime evidence by the people does not require that it must pass the Molyneux test to be admitted. The court wrote, although the parties have cast this appeal in terms of whether the challenged evidence is admissible under Molyneux, we have never held, nor is it the law, that evidence of a prior crime or bad act is admissible only if it passes through the Molyneux prism. While most trial courts are reluctant to find that the defense has opened the door on its summation, this is often the time the defense is the most aggressive and blatant in its addressing areas that should be off limits. Whether it is a fear that reopening the case for more evidence by the people will be subjected to too much scrutiny by the appellate courts, or that it is too late to go back, the trial court should not permit the defense to open the door with impunity on its summation. In the case of People v. de Los Angeles, the court wrote, the court properly exercised its discretion in permitting the people to reopen their case during the defendant Mercedes' summation in order to introduce testimony about a pretrial photo identification of Mercedes, because his summation created an unfair impression about a witness's identification of him, and the photo identification was thus rendered admissible for the first time in the trial. The prejudice to the people caused by this misimpression was a sufficient magnitude to warrant reopening the case during summation, and defense counsel was then allowed to cross-examine the witness and to resume his summation in order to comment upon this new evidence. Another fear the courts may have as to ruling that the door has been opened on summation is that the appellate courts may see this as ineffective assistance of counsel. However, in the case of People v. Gomez, from the year 2008, the appellate court held quite differently. The court wrote, we reject defendant's argument that there could be no reasonable strategic justification for the fact that his trial counsel made a summation argument concerning lack of corroborating evidence as to a certain aspect of the people's case, which led the court to rule that he had opened the door to precluded evidence of uncharged crimes. The record suggests that counsel took a reasonable calculated risk that the court would not preclude his summation argument, which was beneficial to his client as sufficient to permit the people to introduce the precluded evidence, particularly at that late stage of the trial. On the existing record, to the extent it permits review, we find that defense received effective assistance under the state and federal standards. Whenever the defense opens the door and the people are permitted to introduce such evidence on their rebuttal case or even during their direct case, you should request, where appropriate, a curative instruction from the court to the jury that you were precluded from introducing such evidence previously, and that they should not infer anything negative about this evidence due to the timing of its admission. A juror might incorrectly perceive such rebuttal evidence was created to rebut the defense presented, or that you were holding it back, trying to hide it in some way from the jury. When the court rules against the people on their Molyneux application, it is helpful for the court to give the defense a warning that any questioning that would open the door to its admission should be avoided by the defense. This Molyneux warning is similar to the Sandoval warning, which puts the defense on notice, so they cannot claim surprise when they open the door and claim they never would have asked such a question if they had known this would open the door. It also puts the judge in a comfortable position to know that despite the warning, the defense has made a conscious decision to ask the question or present the evidence which they were warned would open the door. In the case of People v. O'Gara from 2005, the court held that their warning to the defense that it would admit hearsay evidence of a confidential tip that was given to the police warning of the defendant's robbery plan if defense opened the door by cross-examining a witness with an investigator's report was a proper exercise of discretion by the trial court to prevent an unexplained mystery and unfair speculation by the jury. Statements by defendants which are not admissions to the present crime but acknowledge other criminal acts are usually precluded. In the case of People v. Nichols from 2008, the court made the following ruling. The trial court properly admitted a portion of defendant's statement to the police following his arrest in this case, in which the defendant mentioned a prior incident even though the other incident could be viewed as an uncharged crime or bad act. Since the defendant attacked the victim's credibility by attempting to show that her version of the defendant's behavior was implausible, the people were entitled to introduce this very limited evidence showing that the defendant behaved in the same manner on a prior occasion. This evidence helped explain the complainant's testimony about defendant's odd behavior and was not admitted to show propensity. Had the people been prohibited from introducing that evidence and thus explaining that it was credible that the defendant would act in an abnormal manner, defendant would have been unfairly able to exploit the bizarreness of his acts. While the introduction of mugshot photo identification evidence will soon be part of the everyday practice in a criminal trial, there are still cases where they may not be used. There is an abundance of case law where the door to otherwise inadmissible photo identification evidence is opened by the defense cross-examining of the people's witnesses on various aspects of the identification or lack of same of the defendant. In the case of People v. Reed, the Court of Appeals dealt with the challenging of the sufficiency of a police investigation. By doing so, the defense opened the door to previously inadmissible Crawford testimony. The defense can open the door to the admission of evidence that would otherwise be barred as a violation of the Confrontation Clause, a Crawford violation. And of course, when appropriate, the defense can open the door to suppressed evidence as well. For more examples of opening the door, please see the comprehensive memo, Opening the Door in New York, Evidence Admissibility. Also, take a look at the memo dealing with rebuttal evidence. Both are found, of course, in the PE. Our thanks, as always, to our crack producer, Jonathan Marconi Crespino. To all of you out there, be well and stay ready, my friends.
Knock, knock, knocking on heaven's door. Knock, knock, knocking on heaven's door.